Transfer of property means a transfer of ownership. One has to differentiate between ownership and possession. In some cases, even though the goods has been sold to the buyer, but title remains with the seller. A good example is cases of hire purchase. This is where a person may be in possession of a car, but the title remains with the bank. Transfer of property in specific and unascertained goods. Generally, the title of the property, which is the ownership of the property, will be transferred to another party when the goods have been sold. Section 18 of the Sales of Goods Act 1957 states that, in the case of the sale of unascertained goods, no property is transferred to the buyer unless and until the goods are ascertained. For example, a contract to buy a new car, which forms part of a larger consignment, no title to be passed until the seller has ascertained which car to be sold. Transfer of property in specific and ascertained goods. Under Section 19 of the Sales of Goods Act 1957, for the sale of specific and ascertained goods, the property is transferred when the parties intend to pass it, and the intention can be known from the terms of the contract and the circumstances of the case. In cases of unconditional contract for sale of specific goods in deliverable state, Section 20 of the Sales of Goods Act 1957 provides that the property and the goods pass to the buyer when the contract is made. Pursuant to Section 21 of the Sales of Goods Act 1957, when the seller is bound to do something to the goods for the purpose of putting them in a deliverable state in a contract of sale of specific goods, the property does not pass until such thing is done and the buyer takes note on this matter. Section 22 of the Sale of Goods Act 1957 states that, when there is a contract for sale of specific goods in a deliverable state, but the seller is bound to weigh, measure, test, or do some other act or thing with reference to the goods for the purpose of ascertaining the price, the property does not pass until such act or thing is done and the buyer has notice thereof. For example, if Ali agrees to sell all remaining sugar contained in a particular bag for 2 ringgit per kilogram, the property does not pass to the buyer until Ali weighs them and the buyer knows that they have been weighed. When do you pass the risk? It is important to ascertain when the property and the good passes to the buyer. This is because the risk transferred together with the property and the goods. This is governed by Section 26 of the Sale of Goods Act 1957. The risk passes when the property and the good passes regardless whether the goods have been delivered or not. The risk will be borne by the owner. This rule depends on the agreement between the parties. However, there are cases where there is default in delivery of the goods. That is covered by the proviso to the Section 26, which states that if the delivery of the goods has been delayed through the fault of the buyer or seller, the risk of the goods would be borne by the party in default.